of our Justice and Pieces guest speaker series. And it's kind of like a full circle moment for me here as I started this just over 6 years ago. It was during the pandemic. And my classes moved from in person to online. I thought, hey, this is like a 2 week. We had like a March break, I think, the week before, and I'm like, oh, this is like a little 2 week break. Let me do something interesting. And I thought, well, let's have like a little series, have some guest speakers virtually. I think we were using Skype, maybe even at the time. And the very first call I put out was probably to my favorite lawyer. No offense to all my other lawyers that have been out here, but my good friend Christopher Sewrattan. So, Chris, thank you so much 6 years ago for joining me. And as you know, the pandemic lasted a lot longer than 2 weeks. The little 2 week project I had has now hit its sixth year, and this is season 7 of Justice and Pieces. So I thought it'd be great to bring you back. I think it's the third or fourth time to see where we've come and see what else you can impart on us from the wonderful world of criminal law. So maybe you could tell us a little bit, for those who don't know you, what you do. And thanks again for joining both at all the times you've been here.
Thanks for having me. Happy to be back. So I am a criminal lawyer in Toronto. I run an eponymous firm name of Sewrattan Criminal Lawyers. What's unique about me is that I actually work with my sister, my little sister Ashley. She and I are the only two lawyers in the firm. We have a law student, we have an assistant, and we do trials and appeals anywhere in Ontario that'll have us. So, and we do everything from, drinking and driving all the way up to first degree murder.
Perfect. So let's maybe start, in terms of criminal law, and you mentioned you do trials and appeals, and perhaps you can kind of give a little overview of, here's what the sort of the trial process is like, and then here's what the appeal process is like, because, are they completely different in terms of preparation?
Right. They are completely different. So when you get a trial, I mean, the first thing you ever do when you get a trial client, if you're going from start to finish, is they're getting arrested and they're freaking out and they're calling you. And you have to give them advice in terms of their detention, like, the right to silence, not to talk to the cops, that they're going to undergo certain processes like fingerprinting, photographs, that the police can lie to them. So one set of information. And then you have to quickly swing to another set, which is about bail. If they're not going to be released at the station, you need to start working with them very quickly on the phone to set up how they're going to actually get bail and be released. From there, then the real work begins, right? You got to start prepping for trial. And that's meticulously going through the evidence. You, as a defense lawyer, you get all of the evidence from the Crown, right? It's an asymmetric discovery opportunity where the Crown has to give the defense everything, and the defense doesn't have to give the Crown anything. So you go through all of the Crown's evidence. You consult with your client. You consult with any defense witnesses that you have extensively, and you kind of map out, your version of events, what really happened here, and you prepare to tell that story to either a judge or jury. And that's the essence of trial preparation.
And then how does that differ, I guess, then from appeal preparation?
Appeals, in many senses, are a lot easier because all of this hard work I just told you is done, right? So on an appeal, there's no witnesses. There's no anticipating what someone's going to say or what evidence might come out. It's all done. You have a transcript of every single thing that happened in the court, and then you have the reasons for judgment. And you share that with the Court of Appeal and you argue based on that. So a trial is like, as a lawyer, you come into court and you're cross-examining witnesses. You're directing the flow of traffic. The judge is just sitting there and watching and taking notes. An appeal is completely different. The appeal court is engaged. They know everything that you know. There's no secrets here. And so it's not like giving a presentation like you are in a trial. You're getting cut off by the judges. You're getting asked questions. You're getting challenged on points. And you have to be prepared to pivot your argument because you're not going to have the passive neutral arbiter that you normally have with the trial.
And so I mean, if you have any tips, because, a lot of junior lawyers, will get into trial and they'll obviously develop over time. But like, let's say on the appeal side first, kind of what you're handling your first appeal, right? Maybe a colleague or friend of yours is, hey, I have this referral for you. What kind of advice you can have in terms of guidance for people in preparing for that, as you said, is very different and in a lot of ways a lot easier to sort of focus on what you want to get from the record to assert your point.
Right. In both trials and appeals, it's all about storytelling. And I'm not talking about fabrications or lying and stuff like that. I'm saying it's all about showing the court what your client feels and what their perspective is, right? And people often forget that, especially if they go to law school, because it's very cut and dry legal analysis, but that's not real life. And people think when you go to appeals because they're so academically based that you're here just to argue fine points of law. And you are, but you're not. You're still here to tell a story. So that's step one is what's your angle? What's the story you want to tell? Ideally, you're telling the story of a person who was charged, put their faith in the justice system for a trial, and was done wrong. And because they were done wrong, the appeal court now needs to step in and fix it. The second thing, and perhaps more important, is preparation. Preparation is the most important thing that a criminal lawyer can do, whether it's trials or appeals. There's not much difference between your favorite criminal lawyer and you, except for the amount of time you can devote to preparation. It reminds me of like, there's a common saying, JP, where people say, talent beats hard work, but hard work will beat talent if talent fails to work hard. That applies perfectly to the practice of criminal law.
Yeah, that's a good point. When I cover the rules of professional conduct or paralegal rules of conduct for paralegals, one of the things I ask students, what do you think the number one complaint about lawyers and paralegals are? And they're always like, oh, fees and they didn't know the law or whatever. And then I'm like, no, the number one complaint is communication, and that
Hmm.
also goes to the workload, right? I mean, if you're taking on like 30 files, as you said, you can't compete with somebody who's doing one or two, and they're dedicated to that. And I've often, with the Crown's office, right, that they have all these files that they're all on, and if you have one big file, like you can focus on that. So, I mean, in terms of that time, if you have that time to prepare, like how do you prepare then? Like, what are the things that you should devote to getting the best results then from your clients at either trials or appeals?
Right. Let's do trials first. Step one for any trial is to go look at the charging document, right? Because it's easy to assume things and skip what can be an easy win. So I'll give you an example because I actually just did something that should have been done by a paralegal. My cousin was charged with careless driving, and the prosecutor wasn't going to resolve this, so we went to trial. And so I went to the traffic court and I got the ticket or the summons, whatever it is, the part three, and looked at it. And careless driving, which if you're a paralegal doing criminal or quasi-criminal law, this is one of the most serious charges you can defend against because the person can go to jail for up to 2 years. And there's two ways to prove careless driving, right? You can prove that someone was, what is it, not acting with due care and intention, or that they weren't acting with reasonable consideration for others on the road. And sometimes the prosecutor will specify which of those two paths they've picked, and they'll forget it. And so they might be able to prove one path, but it's not the path that you're charged with. That's actually what's happening in the case I'm in right now. And all this to say, like, easy wins, don't skip steps, start with the charging document. Then after that, you just look at the prosecution's evidence and look at what their theory is of what happened and poke holes in it. After you've done that, then go to your client, ask them what really happened, and then see how you can weave that narrative into the holes that you've poked in the Crown's case. You put all that together and you have your closing submissions, and you're ready to go.
What about then on the appeal front? How would you kind of tackle that in terms of um, whether it's the written submissions, oral submissions, right? I mean, people nervous to get in front of a appellate body, right? Supreme Court, even potentially, right? What would you say helps in terms of your preparation to maximize the results?
Right. Appeals are a bit trickier because there's not as much consulting with your client because we're all going on the same record. So if step one is just to read the record, right? Read the transcripts, read the reasons for judgment, read all the exhibits and all that. And then you find your legal issues. And then from that, you need to weave your narrative into it. Like, here's where the judge messed up, but like, what's the common thread or why did this happen? And it can be multiple things, right? It could be the judge didn't take the self-represented accused person seriously and was sloppy, or it could be that this was a prosecution of a digital crime, right? Like, well, take your pick, and that you have a judge who's a bit older and doesn't understand how technology works, and the Crown failed to aid them. So that's the narrative that you weave, that digital prosecutions require a certain level of evidence from the Crown, and they failed to do that. Because of that, the judge had a misstep, and so on. Now, you talked about being intimidated on appeal, and I get that. The judges are very smart. But understand, if you're a criminal lawyer, that you have one thing that the appeal court doesn't, which is that you're a criminal lawyer, right? At the Court of Appeal, there's very smart judges, but few of them have done criminal defense. And those that haven't done it for 5, 10, 20 years. And so you know, you have your finger on the pulse of the profession. And so that might be part of your ground of appeal, that the judge, found a Brown and Dunn error, or was upset that the defense counsel didn't object to X, Y, Z. And you can say, look, this is not how we do it in actual practice. And we don't do it for these policy reasons. And you can actually inform the very smart judge about how things are actually happening and give them tools that they need to help them grant your appeal.
So you mentioned the pulse of the profession there. So here we are, March 2026. You've been in criminal law now. I don't even know how many years, like 14 years by my count.
Yeah,
Think 2012, I'm guessing. Trying to do the math from law school there, but so what is the pulse? What's going on right now in criminal defense? Whether on the trial side, appeal side, what are the hot button cases that are taking place and issues that criminal defense lawyers are experiencing that you can share for those who may have no idea, just like you would share for the Court of Appeal judges who may not be practicing today. I mean, who aren't practicing today.
right. So a very like inside baseball answer to that is that we have a junior bar, so junior lawyers on Crown and defense side who came up during the pandemic, which means they came up like this, JP. They came up on Zoom, right? Faces on a screen. And so they've lost the lessons that you might have learned waiting for like a set date, waiting in plea court, just basic etiquette things like standing when the judge talks, you know, um, talking to the judge. You don't talk to your opponent. You don't say, "Oh, JP's wrong because, JP, you're wrong because whatever." You tell the court, Your Honor, Mr. Rodriguez is misinformed because X, Y, Z. And it just brings a certain amount of civility and decorum. And so I know a lot of senior lawyers, a lot of judges are upset at the loss of this decorum because of the pandemic. And I want to be clear, it's nobody's fault, right? It's just a circumstance. And then as well, there's always been an attrition in this profession because it's not the greatest profession. It's long hours, it's a lot of traveling, and the pay is not as good as you can get elsewhere. There's a thinning of the defense bar, especially among women. But there's also, I think, a more recent trend of thinning amongst the crown. They have high caseloads, and that is really tough to meet. And they're junior, so they don't really know what they're doing. They're learning on the fly and making mistakes all over the place. So those are the two recurring issues I see.
Yeah, I mean it's interesting because actually I was covering a criminal law class yesterday, and we were having a discussion about bail and presumption of innocence, and why are the Crown's pleading. And I said, well, like think about resources, right? I mean, if they have five trials and they can't run all five, they gotta
Yeah.
sort of pick. And so I mean, what do you think, from the criminal defense side, like in terms of navigating that as a junior lawyer or brand new lawyer or paralegal for certain summary conviction offenses, kind of how you can kind of navigate that system with that knowledge to do better for your clients.
You have to have mentorship, right? It's like riding a bike. Like you can read about riding a bike all you want, but unless you do it, you're not going to learn. And then if you're starting out, you're going to fall, right? But criminal laws, the stakes are higher than riding a bike because if you fall, someone might go to jail. You need a mentor, someone who's had the wisdom and experience of doing this to guide you, whether that's being an associate, sharing space in a chambers with someone, or just having a mentor. You can't do this alone and figure it out on your own. Otherwise, because everyone makes mistakes, right? Like I make mistakes. It's okay. It's normal. It's the tricky part is how you react to those. And you need the wisdom of someone who's made those mistakes to help you figure out how to react.
So how, I mean, in terms of getting mentorship, and I think this is, especially for paralegals, and I would say also probably in criminal defense, because as you know, most of our colleagues are running their own, practice or have a really small practice if they have maybe another associate or two. So I mean, somebody starting out who may not have those opportunities, where can you find mentorship, or where did you find mentorship? Maybe you can share as well. Starting out in the profession.
So the best place or the easiest place and most effective place is if you're a lawyer to join the Criminal Lawyers Association, right? I used to be a member of the board and an executive there, so it's kind of a plug, but it's not because I'm not there anymore. I'm just a member. But as a junior lawyer, that was the best place because they have a listserv, which is basically a message board that people can ask questions at. They have a mentorship program where they'll pair you up with someone, and it's cost effective because it's like, I don't know, $300 or something a year. You'll make that back tenfold with the experience you get. How I did it though was a bit more intense, where I was everywhere I've worked, I've been in the criminal law chambers, which is just law speak for an office building with lots of criminal lawyers in it. So there were always more senior lawyers than me who, because I'm there every day and they see I'm working hard, they don't mind spending time giving me advice and letting me bounce questions off of them. And so that's how I've learned to navigate this profession.
Yeah, and maybe more broadly, I guess, since you're not on the CLA board anymore, but you're involved in a different organization. I mean, that provides mentorship not just for criminal lawyers, but maybe you can tell us a little bit about your work with SABA.
That's right. I'm a board member of the South Asian Bar Association of Toronto, more commonly called SABA, which is quite unique an experience for me because I've always been involved in criminal law or criminal adjacent organizations. But on SABA, it's much more corporate or civil based. I'm the only criminal lawyer on the board. SABA has its membership is it's I think it's the largest diversity organization, legal diversity organization in Canada. So we have all sorts of members, but a significant portion are lawyers who got their training abroad, namely in India, and then have completed their NCAs and are starting out here. They have tons of legal experience, but zero Canadian legal experience. So they very much want and need mentorship. It's been a great resource for them because they connect with me and I've been connecting, like my criminal law peers to the organization to give mentorship to these people.
And also on that mentorship front, you keep forgetting all the other things you do. So I gotta remind you here, nudge you gently. But like myself, you've been in education. So maybe you could tell us a little bit about what it was like being a professor, or still, I think you're still a professor there at TMU, and some other places you've gone. I know you still support your Scarborough alum, like I support mine, our rival West Hill and uh, St. John Paul II there. But maybe you could tell us a little bit more about that and why those, again, providing those opportunities for whether they're high school students or law school students or wherever are important too.
Yeah, so I actually did forget about all that. I'm a I guess commonly referred to as a law professor at the TMU's law school. The contract that we signed though calls us a lecturer, so I suppose that's the more correct term. But if it was at Osgoode, I'd be a professor, so or adjunct prof. I teach criminal procedure there. I have for 4 years, and I really enjoy it. Criminal procedure is not what it sounds like. It is charter rights, bail hearings, guilty pleas, like the bread and butter of criminal law, except we don't teach actual substantive criminal law. I don't teach actus reus, mens rea, defenses, excuses, stuff like that. And then, yeah, going back more to home, I went to this high school in Scarborough called West Hill Collegiate Institute. It's across the road from JP's old high school. And as soon as I became a lawyer in 2012, and then once I actually knew what I was doing in 2013, I started volunteering there, and I've been doing it every year since. where I just mentor the law students. I give them lectures on various topics, and then every year we have a big tournament in Toronto, run by OGIN, mock trial tournament. So I always co-coach the team with either another community volunteer or the law teacher.
And that's all great. And I think again, certainly mentorship at all levels is important. And it's also important for any of my students listening that, you don't just wait for people like Chris to come and find you. You got to go and find people like Chris, whether on LinkedIn, and I know other social media, or even pick up the phone, I suppose, and call. But actually, speaking of LinkedIn, I mean, the other thing is, you have a very large presence on the social media platform formerly known as Twitter, right? X there. And I remember, and I think you've won obviously another thing that we have, the Clawbee,
Oh
for
yeah.
essentially your your tweets and about the appeals. And so kind of maybe you could talk about you know uh, sharing information, and how that came about, and maintaining kind of ties to the community, as you said, keeping your pulse on the profession. I mean, even if you're not necessarily running an appeal right now, it's like, well, what's going on, and sharing that information.
Right. So for those who don't know, from for almost a decade, I was doing tweets on Twitter about Court of Appeal cases. I read the Court of Appeal every single day, Monday through Friday. Well, I read the criminal judgments every single day, and I've been doing that since 2010. By 2014, I finally joined Twitter, and I was trying to figure out like what am I going to tweet about? Because as we all know, if you're not focused on Twitter, you can end up saying some really dumb things that you might regret. So I just only tweeted about the things I was reading, which was the Court of Appeals website. It caught fire, and by the 2020s, I had tons of followers. And anytime I'd go to like any of these teaching events, judges would come up to me from across the country. Like I remember this one guy from judge from, I'll say the East Coast, was like, "We follow your tweets, all of us in the courthouse, to see what like Toronto lawyers are doing and how they're treating like the defense perspective." And it was great. But then if you were on Twitter long enough, it became a real cesspool of all sorts of nefarious things. And this is what broke the camel's back for me. I was at another teaching thing. I ran into a judge, and he said, I don't really use Twitter anymore, but I log in just to see your tweets. And he was trying to compliment me. It was nice. But I was like, that's it. I don't want to be the reason anyone's staying on this website anymore. So I cut it off and I moved to Blue Sky. And I mean, people might read it, but I get zero, like literally zero engagement. I've been tweeting for years or whatever, posting on Blue Sky. Um, but whatever, I'm going to keep doing it because I keep reading the court no matter what, and I post my ideas. I'll just transition to something, which is because you mentioned LinkedIn. I don't know if anyone saw this coming at the time, but LinkedIn seems to have supplanted the like criminal legal social media community. Like people are on LinkedIn now, and I see people summarizing cases on LinkedIn, and there's engagement and this and that. I've considered doing it because certainly it would at least reach more people. The reason I don't do it is because I find it to be the wrong forum, right? Like with Twitter, especially, people would challenge your opinions, which would, sometimes it was annoying, but oftentimes it was in good faith and engaging. If you're wrong on LinkedIn, you're wrong in front of your entire professional network, right? I don't want that kind of heat because I'm shooting from the hip every day, right? I'm quickly reading the case, summarizing it, and sending something out. It's not a polished piece of work. It's not my best work. So I don't want that kind of smoke. So keep it humble, like a mumble on Blue Sky.
Yeah, I mean, I guess that's true, right? And then also, anybody could be waiting in on like, your mama or something, actually who I follow on Facebook. That's how I know actually what's going on.
Right.
Congratulations on the certified specialist. I found it from your mom actually. But I mean, actually on that as well. I mean, speaking of all the stuff, the CLA had, I think it's a CLA, but who sort of has carriage of it, the Supreme Court podcast series that you were involved with, or I don't know if you're still involved with. And so, how did that kind of come about, in terms of, again, presence and doing things outside of the practice?
Damn it, you're doing a deep dive into my bio. Like people don't know about this. So the CLA has a podcast called Canada's Court. If you drive a lot to court, which a lot of defense lawyers do, you just kind of want to listen to something. you don't have to pay attention to, like background noise, but you might want to learn something. So what we did is we got the audio from every single criminal case at the Supreme Court, and excuse me, we publish it. And before every episode, we have a criminal lawyer summarizing what the case was about. So you at least have you're up to speed on what you're about to listen to. And you can hear the best criminal lawyers advocating at the highest level. That is, I'll safely say that's my podcast. That's my baby. That's an idea I had since the 2010s. And it took over a year, JP. I had to write to the Chief Justice of the Supreme Court, to his office, do this whole back and forth, had to sign contracts to get the license, because you need a license to reproduce that info. And we got the license. So that's what we do. The podcast is still going. We just started season 10 last week. At least we've started planning it. And it's got on, like, in our first year, we had 50 something thousand listeners. And I would have hoped that in the 5 or 6 years since that we have more. So it's caught fire. The next step that I'm looking into, and if anyone has the answer to this, please email me. I'm trying to find someone who has an AI device that will allow us to read criminal Supreme Court judgments, but like perfectly and without going through the citations, right? There used to be a person that did that called, I think it was called Dicta. The guy's name was Travis, but I can't find him. But that would be the next step where someone could listen to the oral argument. And then in the next episode, you could have a reading of the judgment of the argument that you just heard.
Yeah, that'd be again with technology certainly, and maybe we could actually talk about this in a little bit. But I just was prompted there when you're looking at editing and have the introduction from a lawyer. But as we're both we've traveled to Florida together to watch WrestleMania. But I'm just thinking like. What would be maybe it's just me, but before when people walk out, when you have John Cena come out and you have all of them, they have a music, they have a whole mannerism, but if you're editing like the Supreme Court, when they all walk in, you could have like walk out music, right? Whether it's whoever of our colleagues there, but if you got a chance there, if you're like, look, Chris is walking in, robed up and all. What are you coming out to, and how are you mean mugging for the camera at the Supreme Court?
um, if I was a judge, you know what so I would do Snap Your Fingers. I don't even know who sings that song. It might be Lil Jon. But the reason is in the heyday of Jose Bautista with the Jays, like 2010, when he hit 50 something home runs, that was his walkout song. But he'd only have the part that goes, snap his fingers. And that's it. Cut it off. That's all I'd have. But and if I was counsel though, defense counsel, and I had a walkout song at the Supreme Court, it would be Many Men by 50 Cent.
It's just the intro alone on Many Men,
Yeah.
with the gunshots there. Speaking of the Supreme Court, I mean, this week there was a big appeal. I think I heard it was the appeal to end all appeals. So maybe you could tell us a little bit about that and kind of why it's been given this sort of elevate. I know there was many interveners, and you could also talk about intervening because I know you have intervened as well, and how that's a little different than actually arguing there because we talked about your own appeals and successful appeals and stuff that you've had. But what first of all, let's go. What's the case about, and then if you can dive into getting an opportunity to intervene. What's your focus and why do people do that?
Right. So the appeal is called Montreal English School Board and Quebec Attorney General. So it's a school board versus Quebec, but there was many parties. And what happened is there's a law that Quebec passed in 2019, and they preemptively used the notwithstanding clause because they knew it was going to violate all sorts of rights. And it basically says that government employees or people that work in the government sphere within the public cannot have religious markers. They can't wear them while they do it. So if you wear a hijab, you can't be a teacher. If you wear anything else, like you can't be a police officer, you can't be a crown attorney, you can't be a judge. And they use the notwithstanding clause. So like, yeah, it violates your charter rights, but so what? Too bad, right? Legislative supremacy. So it's worked its way up all the way to the Supreme Court of Canada, and it's drawn all this attention for two fundamental reasons. The first is political. This is a powerful political issue in Quebec about the preservation of, Quebecois values, like I'm going to mispronounce it, but I think it's called laïcité. It's like it's not secularism, but it's a version of secularism that was first espoused in France and now is being taken up in Quebec. And so if, the non-Quebec Supreme Court of Canada, right, like the rest of Canada, uh, impairs Quebec's ability to uphold this type of cultural value, it will be seen as a major affront from Canada to Quebec. And they coincidentally have a provincial election this fall, so it could very much influence the results of an election, which if you're a court, you don't want to be doing that. Stay out of the political sphere. The second thing, and the more nerdy thing about it, is the Supreme Court can weigh in for the first time on all sorts of intricacies on how to use the notwithstanding clause. For example, can a province actually use it preemptively? Or do they need to first have a court strike it down with a judicial decision and then they can use it? And if they do use it preemptively, can a court still weigh in on the constitutionality of the law? Like, does it still violate charter rights? Yes or no? The court is very skittish about weighing into the political sphere, and this case is bringing them right into it. For what it's worth, I think the answers are all simple. Yes, Quebec can use the notwithstanding clause. Yes, they can use it preemptively. And once they use it preemptively, I think it still remains open to a court to review the use of that and just to say, yes, it violates these charter rights in this way, but it operates notwithstanding because they've used the notwithstanding clause, right? It's a big nothing in terms of legal doctrine, in my view. And first of all, I'm just a nobody. I stand to be corrected, right? They have 7 very smart judges dealing with this. But that's the way I see it going. Interventions, which was the next part of your question. They had like 40 interveners. This is the Groucho Marx saying, JP, like, I wouldn't want to be part of any club that would have me. So I've been blessed and fortunate enough to be granted status as counsel to act on behalf of different interveners at the Supreme Court. So I've done it. It's overrated. Okay, it's overrated. If you see anyone bragging that they intervened at the Supreme Court of Canada, frankly, I think you should roll your eyes. They're telling you as a friend, great, encourage your friends. If you see it as a post on LinkedIn, come on. You get 10 pages of a fact at best, right? So you have a written argument, great. And that's the most important thing that you do. You get 5 minutes for oral argument. Think about 5 minutes. I probably spent 5 minutes answering this question already. You know, 5 minutes. They don't even let you into the building. You cannot even go to the Supreme Court of Canada. You have to do it by Zoom. And I've done a few of these and I've watched quite a bit because again, I run that podcast. They don't ask questions. It's like 1984. You're a big face on a screen. They have these big, 37-inch monitors, maybe 42-inch in the Supreme Court. Everyone looks at it. They let you say your piece. The worst advocates are just repeating their facta. The best advocates are picking up on questions the judge had asked earlier to the actual parties to the appeal. But you get 5 minutes, you get no questions, and you say your piece. That's it. And if you're the junior on the file, you don't even show up on the Zoom screen. You can dress up in your gowns all you want and take a selfie, but nobody even sees you.
Oh, that's interesting. I've never, we actually, it's really ironic because I had to cover this class and it's like all these things that were in the. I'm gonna like listen to Chris. He explains it a lot more better. But no, it's a great perspective because everyone may think differently. That hey, you get this time and you can certainly advocate positions from your organization or the perspectives there. But actually on that oral advocacy piece, right? And I mean, there's sort of two parts here. Maybe I'll give them both to you. You can kind of address them however. But one is, no, earlier you were talking about exactly like what we're doing here, right? It's on Zoom. Now, how are you advocating whether, I mean, well, actually, now I have a third question. I'll put them all together. The third one is like, what's happening in court right now? Are we in court again? Are we still kind of mix and match of oral versus in-person submissions and trials and so forth? Then the piece was that I was getting at before was, how do you advocate on Zoom versus how do you advocate in person? Is there a difference? And thirdly, there is to the original question is how much is that oral advocacy on an appeal? Let's leave the intervener piece out altogether, but as an actual appellant, right? How much does that sway the end, right? It's not like, oh, Chris was so well versed. His legal arguments on paper were, suspect, but I got to give it to him because, I mean, I have a lot of students who moot, right, where that is a factor. So I know it's a huge three-piecer there, but however you want to go about it, just flowing from the hip here.
Sure. So how is it being done right now? Anything that matters is being done in person. We've lost almost all of the gains of the pandemic, depending on your perspective. I don't like going to court unless I have to, but if you're going to do a guilty plea in Toronto, if you want to do a peace bond, basically, and if you want to get heard before 1 o'clock, court starts at 9, you got to go in person. If you're doing a trial, in person. Appeals at the Court of Appeal, in person. The only exception is what's called summary conviction appeals, which, no, I guess paralegals can't do it because there's summary elections, but they're in the Superior Court. And those are presumptively by Zoom. But even still, I ask for an exception and to come in person. Because, and this is the second part of your question, what's the difference in advocacy? Well, you can probably tell in this interview, I speak with a lot of pauses. I think I don't have a script and I don't rush into it. Um, so that's better in person. I stare people in the eye, right? Whereas if you try to do that style on Zoom, it just looks like your screen is freezing, right? You lose that. The funny thing is, I'm a millennial. I think I'm pretty well versed in the computer. So even if I'm in person, I'm throwing up all my material on a screen and making them look at a monitor anyway, right? So sometimes on Zoom that's very effective, especially if you're in the Superior Court. They make you use something called case center. Used to be called case lines. So like I just did one this week in summary conviction in person, but the whole time I have case lines on a monitor in front of the judge and I'm showing her the digital material, right? So that's two. Your third one, what was the last piece?
How much does that really make the difference? I guess, I mean, certainly in a trial, you could probably talk about that as well, because, I would think it's a little different there than at an appeal.
Right. So, well, so look, a trial, there's a rule called hearsay, right? You can't have an out of court statement taken for the truth of its contents. And what that boils down to is trial information is done live in court. So the oral presentation is everything, right? Because the jury or the judge won't have anything written in advance. An appeal, like we've alluded to earlier, is the opposite. Everything's written in advance. In that situation on appeals, oral advocacy is like 5, maximum 10% of persuasion. The heart and soul of your appeal is the factum. So that's where all your attention needs to be. It needs to be as perfect as possible. The oral advocacy is an opportunity to clarify. The court is going to come in having read your stuff and just have kind of pinpoint questions, really just cut to the chase, right? There are exceptions, and that's the Court of Appeals sits 3 judges. Typically, if you're doing criminal law, you'll have 1 criminal expert on the panel, but sometimes you might not have any. And so they might need a little bit of brushing up on the law, in which case your oral advocacy is it's more important because it's more helpful, right? Same thing with the Supreme Court, kind of. 9 judges, but I'm trying to think, like, they don't really have a resident criminal law expert. Justice Sheila Martin right now, I guess, is their expert. And, she's been a judge for longer than she was a criminal lawyer. So you kind of might need to walk them up and brush them up on the law, but more on the very nuanced points, not like obviously the bread and butter, because they know that stuff.
And what would you say, from everything, we actually there's one other thing, from your deep dive in bio, because I know on Monday I'm teaching tribunals, and I believe it is the license appeal tribunal, and of all the things, there's also a little, if you had a bio, maybe it'll be buried in the footnote there,
Yeah.
as you were an adjudicator there. So what was that? How did that come about? And what's the experience there, and how has that helped you with everything else you do?
So yeah, for those who don't know, excuse me, in I don't even know what year, 2016. for about 3 or 4 years. I was an adjudicator on the License Appeal Tribunal of Ontario. It's a huge tribunal, covers a vast swath of jurisdiction in terms of content. And so I was specifically placed into the part of the tribunal that does automobile accident benefits. So anyone that does that knows we deal with the SABS, statutory accident benefit schedule. And I'm a criminal lawyer. I remember I walked into the interview and I thought we were going to talk about taking people's licenses away, like the driver's license. And they made me write an essay on automobile accident benefits. And I just kind of made it up. you know, I was like, I don't know. I guess if you get an accident, I guess you need benefits. It makes sense. I pay insurance. And somehow I got hired. And then I just started, I'm my strength is legal research and writing. So they do a lot of case conferences where matters settle. Like the vast majority of stuff settles. But then the more rare set of stuff goes to trial. And not that people don't want to do trials, but they're a different part of the brain. They're pretty hard work. They're intense. And that's my wheelhouse. I was like, yeah, let's do it. I do trials all the time as a lawyer. So I did tons and tons of hearings. I used to publish, like I was a part-time member, but I think I was at the time like I had the most judgments of any adjudicator. I write dozens and dozens a year. And what I learned, it was great because finally got the perspective of what does a judge look for? Like, what do you actually need in order to agree with a side? And you'd be surprised. Like the fundamental lesson I learned was follow the legal test in your submissions because the adjudicator, judge, whomever is going to have to do the same thing. So if you do the work for me, I'm more inclined to adopt it than if you don't, and I just got to start from scratch. Of course, the equities and the actual facts matter, but at a certain analytical level, like you just want some help.
Yeah, and kind of to put all of this package there together, all the things we've talked about, the different things that you've done and are involved with. I mean, all of that comes back to the fact that it is Sewrattan criminal lawyers, right? And if you were, I mean, not to say that if you had an employer that they wouldn't also be supportive, but having your own or leading your practice with your sister, how did that kind of come about? And what have you learned? Also, a reminder if I post this in time, the 31st is the annual report deadline for everybody listening. But what is that like in terms of the business aspect of it? Because we know we went to law school, and we have a program actually in all the paralegal places I teach where they learn to run a business. But we didn't really learn that, and I mean that takes up a significant amount of time. Whether it's the annual reports, whether it's the spot audits could happen, the CRA, all of these things. So, what have you learned in the years of running a business, and especially in criminal law? How does that kind of tie into? Now, you mentioned obviously the advantages of chambers, but anything else you can share for somebody in terms of the business side of criminal law?
Yeah, I had a crash course in the business because we didn't learn that in law school. And the best advice is to learn the fundamentals early, right? So the Law Society, they have the rules, but they also have like resources for people starting their own firms and inhale that information. Study for it as if you were studying the actual law. And because if you do that, you'll build good habits. And once you learn the habits, it's easy after that, right? Like it's like brushing my teeth at this point, doing my trust reconciliations and this and that. So that was easy. You asked about Ashley. It was a pandemic related happy coincidence. So 2020 hit. Ashley, I think she was working like insurance defense. She enjoyed the people, but didn't enjoy the law. And I was starting to get, for the first time, first degree murder trials on my own. I used to be a junior for stuff, and now I was lead counsel, and it was too much. Oh, and my wife had kids. My wife and I had kids. So I had other responsibilities and other devotions of my time. So I needed someone to hire, and she needed a job that wasn't insurance defense. She had articled in criminal law, so I think it was through like my mom or something. My mom was like, Ashley's looking for a job. I was like, okay, okay, okay. Let me talk to her. And then she started in 2020. Now it's 2026, so it's been 6 years. It's worked great. And the last bit I'll say is, yeah, like for those who are intimidated about going out on your own, do it. It's the best choice you'll ever make. You get to control your freedom, you get to do what you want. Like, look at me. I'm a serious criminal lawyer, senior criminal lawyer. I have an Inception poster behind me, right? If I I am going to intervene at the Supreme Court in May, and it is going to be 5 minutes by Zoom because they won't let me in the building. And they're going to be looking at the same orange Inception poster as you. And nobody can say anything because I'm my own boss.
Yeah, I guess it's better the Inception poster than the undisputed era championship belt. I don't know where that is. That still up in your office?
We got it.
There we
I do
go.
whatever I want. It's
The,
the
the
best. It's the best job. I'm the best boss in the world because I'm my own boss.
except that if your mom is like, you're being too hard on Ashley, I suppose. So thank you so much, Chris. I don't know if there's anything else you wanted to highlight besides being the champ there that you haven't got a chance to talk about, over the hour here.
Work hard, be humble, try to have fun in this profession. Like if you're doing criminal law or if you're paralegal doing regulatory stuff, like there's serious consequences in the incident that happened. Like people might have died or got hurt, so it's not a joke. But try to find joy in your job because otherwise you'll burn out pretty quickly. And suppose we should close this with who are your three top wrestlers of all time? All time.
All time. I'm looking up here on my wall. It's probably Bret Hart. I would have had the last time I had the Bret Hart shirt, but we were recording and it didn't work. And then I would say probably Stone Cold and The Rock.
That's a good list. That's a
So
good list.
Mount, I don't know who would be four. They have the Mount Rushmore, right? So I would say that would be my three. Uh, Fourth, I mean, it could go. I mean, you got the Undertaker, maybe. Um, yeah, that the fourth spot is always the challenge. What about yourself? Who would be on your top
Kurt
three?
Angle. Kurt Angle's number one. Bret Hart. And I mean, that's such a Canadian thing too, right?
Yeah,
To love Bret Hart. Is two. I think you got to put Cena up. And yeah, it's hard to fourth one. I know you want me to say Stone Cold or something, but honestly, Roman Reigns.
Roman Reigns. So I guess
People
I'll
will look
probably.
back at this era fondly.
Yeah, I see that
Yeah.
he's up. I have that. I have it posted right here with the bloodline with the fingers to the air there. Actually, I'm wearing a Jey Uso shirt, ironically enough. Not planned here, but as always, thank you so much, Chris. I very appreciate it. I think we covered all sorts of things very organically, and it's great that you do all those things, right? I think it makes a well-rounded perspective for anyone listening, right? That you can do all those things, right? And you're not just Chris Sewrattan, criminal lawyer, and that's it, right? I mean, you can be doing things whether it's with Saba, whether it's stuff on the other boards, whether you had time as an adjudicator, as a lecturer, or whatever they want to call it for the pay grade there,
Yeah.
volunteering. I think you have a law award at West Hill on top of things, right? So it's great there. Your mom will be like, "Oh, look at my son." I'm sure gonna see the post there. Certified specialist Chris Sewrattan. But and you have time obviously to spend time with your family there. Make sure at your next birthday party you shout out Sophia first. But all the best and take care.
All right. Take care.